everyone, to this preview session on behalf of the American Society of International Law and the Latin American Society of International Law. I'm Gregory Schaefer, ASIL's President-elect nominee, Chair of its Colleague Societies Initiative, and Chancellor's Professor at the University of California, Irvine School of Law. Around 40% of ASIL's membership resides outside of the United States. In an ongoing effort to reach out to all of our members, we have organized a series of preview sessions with our colleague societies in each region in the world. Our virtual annual meeting begins next Wednesday, March 24th, entitled Reconceiving International Law, Creativity in Times of Crisis. You can find the program on ASIL's website with its impressive list of speakers addressing critical issues of our time. As a preview to the meeting, we have organized this month, for the first time, a series of regional collaborations with our regional colleague societies for each region of the world in Africa, Asia, Europe, and Latin America. Today, for this preview session, we are collaborating with our colleague society, the Latin American Society of International Law. I turn this over now to my esteemed colleague, the president of the Latin American Society of International Law, Sylvia Fernandez Degramundi, who also is president of the states parties to the Assembly of States Parties to the Rome Statute of the International Criminal Court, where she previously was judge and president of the court itself. Sylvia.
Thank you. Let me at the outset congratulate you, Professor Schaefer, for this initiative of reaching out to regional societies of international law to contribute to this conversation. I am delighted to participate in this preview session on behalf of the Latin American Society of International Law, together with such a distinguished panel of jurists from my region, including Judge Maria Teresa Infante, who was my predecessor as president of our society. The Latin American Society is still quite young, having been founded in 2007 with the aim of promoting international law in our region and the world through an active network of jurists and practitioners of Latin America. To meet its objective, the Society has the academic guidance of an executive council made up of prestigious jurists, including two of our panelists today, General Director of the Society, Professor Jorge Viñuales, and the Executive Director, Professor Alberto do Amaral Jr., who ensures the essential technical support for the development of the association and the execution of its activity. Successive biannual conferences in various Latin American cities, the most recent one in Buenos Aires, Argentina, have contributed to the consolidation of a Latin American legal community that, while reaffirming its own identity, wishes to contribute to the development of international law globally. So I am very pleased to be here today on behalf of the Society, and I would like now to turn to our distinguished panel, which will be moderated by Lucinda Lowe. Lucinda is a partner of Steptoe and Johnson LLP, based in the firm's Washington, DC office, where she currently serves as the firm's international practice leader. She is also a past president of the American Society of International Law from 2016 to 2018, and her legal practice is focused on investments dispute, anti-corruption, and other international regulatory compliance matters. She has extensive experience in Latin America and has lived in Brazil on 2 separate occasions. So Lucinda, all yours.
Thank you very much, Sylvia and Greg. It's really a pleasure and honor to be part of this inaugural global engagement series and to moderate this program on investment, human rights, and sustainable development in a changing Latin American order. We have a number of topics we want to touch on during this hour, and a diverse and distinguished panel of speakers to explore these topics drawn from various parts of the continent. In the interest of time, I'm going to introduce the panelists only briefly. In alphabetical order, they are Alberto do Amaral, Jr. Dr. Amaral is an associate professor of international law at the University of São Paulo and a director, as you heard, of the Latin American Society of International Law. He's been a visiting researcher at Yale Law School and is a member of the editorial board of the journal Global Constitutionalism. He has multiple books, which I won't detail, but I commend to you. Maria Teresa Infante, as you have heard, is the immediate past president of the Latin America Society. She's also been the director of the Institute of International Studies of the University of Chile and has been and currently is co-director of the LLM program on investments, trade, and arbitration, which is a joint offering of the University of Heidelberg and the University of Chile, as well as a member of the Institute of International Law and many other things. She's served in the Chilean government. She's an ambassador by rank. And last year, she was elected to take up a position as a judge with the International Tribunal for the Law of the Sea. Dr. Pedro Martinez Fraga is the co-leader globally of the Brian Cave Leighton Paisner LLP International Arbitration Practice. He's a member of the NYU School of Law adjunct faculty and holds the designation of Distinguished Visiting Practitioner of the NYU School of Law Center for International Arbitration, Litigation, and Commercial Law. In December 2015, the United States appointed him at the same time I was appointed, actually, to serve on the ICSID World Bank panel of conciliators. He's been lead counsel to 8 countries in connection with international disputes and has extensive publications, as really all of our panelists do. And last but not least, we have Jorge Vinuales. Dr. Vinuales holds the Harold Samuel Chair at the University of Cambridge and is a fellow of the Lauterbach Center for International Law and of Clare College. He's a Director General, as you heard, of the Latin American Society of International Law. He's also an associé of the Institut du Droit International. At Cambridge, he founded and directed the Cambridge Center for Environment, Energy, and Natural Resource Governance, and he's published many studies on international law and has wide experience as counsel, expert, and adjudicator. We're going to proceed today in a kind of roundtable fashion, with one of our panelists taking the lead on a topic and the others commenting. Time permits, we'll take a few questions at the end, so please send them through on the Q&A function on your Zoom platform. So let's start with international economic law. And I'm going to direct my first question to Pedro. Pedro, what trends do you see in the free trade agreements in the hemisphere, and what do you think we should expect from the Biden-Harris administration in relation to such agreements in the region? And how, this is a bundle of questions really, how does the new NAFTA, which some call USMACA, play into this? Pedro, the floor is yours.
Thank you. I think that's subject or susceptible to an objection on the grounds of being a compound question. But I think we can see 4 very basic trends, all of which are interrelated and not at all separate and distinct. Foundationally, we see, for the first time, really, a new generation of treaties that empower, for example, gender equality, sustainable development, labor, through economic development and trade in particular. So we're seeing treaties that are green or greener than they ever were before. We see gender equality as being foremost, as well as comprehensive labor strictures, going through the entire gamut. But I think that really to address the issues as succinctly as possible, we see this trend in 4 different foundational contexts. The first context is through the practice of states. And here I would identify Australia, Chile, Canada, and New Zealand as major players who are engaging in treaty practice that is bolstering green FTAs and it's more than just turning a neutral eye towards these issues of sustainable development, gender equality, labor, and labor, very broad labor, collective bargaining, no forced labor, minority wage limits, minimum wages, child labor, forced labor, the entire gamut, but actually a responsiveness to these issues. So the first is the treaty practice that we see with countries. Uruguay should probably be a part of that list too, since we're talking about Latin America. The second, I would say, are the EU treaties. Of course, the EU and the United States, the TTIP, the EU and Canada, CETA, and of course, the EU and Mercosur. And in fact, if you look closely at that EU Mercosur treaty, you will see, I think it's in Article 6, that that labor is foundationally treated and elaborated upon. It also has some very interesting gender equality provisions. So we see that second pillar of treaties. The third pillar or group of treaties are the treaties that are being spawned within Latin America. And here I think that the Uruguay-Chile treaty is particularly telling, helpful, eloquent in general regards with respect to gender equality, labor, sustainability, these foundational issues. So we're seeing that conceptual development, formation, and transformation, where actually successful free trade, economic growth, is understanding as a condition precedent that these issues need and must be addressed. And finally, the fourth pillar that I can identify as a discernible trend are the old treaties, quote unquote old treaties, the post-Nafta treaties that were, created in the wake of market liberalization, which was the NAFTA objective as of January 1st, 1994. And those are treaties like the Colombia-U.S. TPA, May 15, 2012 treaty, and also the Canada-Chile treaty. I think I would lump in there. I think that's a 1997 treaty, even though it's been updated twice, and I think as recently as last year, maybe. So that's a category of treaty where you have the old NAFTA structure, but updated over time. Now, this is all, I believe, generally speaking, great news. But within that trend, we also have a lot of space and room to grow. We find that, for example, to use gender as an example, where these provisions are placed are hardly uniform amongst and between and throughout the treaties. Therefore, the importance that they're given is debatable. We find some treaties that explicitly remove, for example, gender issues from dispute settlement. That's disconcerting. I've identified one treaty. I think it may be Israel, Chile, I believe. I don't recall. I should have it in my notes, but that is a fairly progressive treaty that does submit gender-related issues to dispute settlement. But for the most part, they're either excluded from dispute settlement or alternatively not mentioned at all. But in any event, in terms of dispute resolution, the dispute resolution that is attendant to these concerns is a very watered down dispute resolution. It's state to state, and as we know, in the history, leaving aside the tribunals that are the claims tribunal, there have only been 6 state to state arbitrations in the context of investor state ISDS disputes, and only 4 of those actually reached panel report. So these are palpable and remaining concerns. Finally, the last part of your question, and I'll be very, very, very brief. The NAFTA, the USMAC or CUSMA, depending on where you live or come from or how universal you want to be. Look, I don't think it's going to be the NAFTA, and it's too early on to understand. The NAFTA spawned 6 treaties affecting 12 countries and 4 bids. And they are all modeled, the Peru US FTA, the US Colombia FTA, all these are little NAFTAs with with very few changes, certainly with respect to the investor chapter and the financial services investor chapters, the NAFTA tantamounts to chapters 11 and 14. This is not going to be, in my opinion, anything close to that because the ISDS piece has been cut off, and I think it's been negotiated in a context where liberalization of markets and globalization has been viewed as a necessary evil. ISDS has been severely curtailed without understanding that if investment outside one of the three NAFTA countries requires protections. And that was a concern back in the NAFTA, which was a treaty, of course, of many firsts. The first to have ISDS, the first to have a separate financial services investors chapter with ISDS, although limited to some extent. So we will see. The important part of this is just that the multilateralism that is in all of these treaties, I think the Biden-Harris administration will galvanize, will make better. And so there's a lot of hope with this administration, and the sounds of the administration early on have been positive. So with that, I think I've more than met my quota.
And thank you, Pedro. And sorry to throw you a compound question on the first pitch, as it were, but you covered a lot of ground in a short while. So let me direct a follow-up question to Alberto. Pedro's mentioned a number of different treaties, but China's on many people's minds today. How does China play into the picture? The treaty picture in the trade area in particular with Latin America, and I'm particularly interested in your perspective given the extent of the Brazil-China trading relationship. Can you comment very briefly on this?
Yes. Greetings, everyone. First of all, I want to embody my gratitude to Brazil, particularly to Gregory Schaefer, for organizing this splendid initiative. I highlight initially the following fact. What has changed in the relationship in Latin America when we think in the United States and China? What changed was that and is that in the past, Latin American countries had a high level political and economic relationships with the United States. And now Latin American countries continue to have a high level political relations with the United States, but they maintain, they initiated a high density economic relationship with China. This is the first point. And Latin America became one of the theaters of the hot competition between the United States and China. And this can be divided at least in two periods. The first period is from our begin in 2000 and goes until 2015. And this period is fundamentally characterized by the fact that the trade between Latin American countries and China expanded. Mainly Latin American countries exporting raw materials and importing manufacturers. The second phase is not able to repeat the same pace of economic growth, but it experiences a diversification of relationship between the Latin American countries and China. And other sectors, investments, infrastructure, manufacturers, and digital economy are at issue. In the Brazilian case, for example, the 5G is one of the most important questions involving the giant Chinese enterprise highway. And Brazil will promote in the next month the bid where this question will be fundamentally discussed. But I should add another point that China became the main Brazil's trading partner, the main Argentina's trading partner, the main Uruguay's trading partner, a great Chile's trading party. And this involves also on the part of China, a proposal to create a free trade area between China and Mercosur. But the great problem is related to Paraguay. Paraguay maintains diplomatic relationship with Taiwan and not with Beijing. These are the most important questions, and I stress the fact that we will have a diversification of relationship with an emphasis in technology in the near years in the future.
Thank you, Alberto. And we're getting some questions on the Q&A, so maybe we'll come back to some of this later. It's important, but Maria Teresa, 2 FTAs that Chile has have already been mentioned. Give us the Chilean perspective on this.
Well, the Chilean perspective is permeated by a long-standing practice of signing bilateral free trade agreements and multilateral free trade agreements. The last negotiations that took place in the Pacific Rim was a successful one, but politically difficult to pass through Parliament because of the changing scenario, the changing context of political and economic context in Latin America, and also because of the domestic situation in Chile. What I see from the Chilean perspective is there are 2 phenomena that are influencing the debate. One is the circumstances surrounding the discussion and adoption of a new constitution. The democratic foundations, human rights, principles relevant to safeguard the division of power, and the construction of a shared vision on a social political elements. That is a context that to some extent influences the whole short-term vision in Chile. And second, it is the influence, which is imperceptible, of international, transnational discussions, like those taking place in UNCITRAL, OECD, WTO, regional agreements, the Pacific Alliance, the failed experiment of UNASUR, that inspired many views about the role of international law, the relationship with domestic law, and at the same time, the ability of state to conduct what I would call public policies according to sovereign decisions, trying to some extent to put the 2 issues like opposite ones, international law and the domestic setting. So Chileans and Latin Americans are facing a tremendous challenge to coordinate and to make those areas to work together. And I would like to say that 1 or 2 points to conclude this intervention. The impact of the changing perspectives that some agreements signed between Chile and some countries because of the Brazilian initiative to sign trade agreements and investment agreements taking a different pattern, could have had a tremendous influence in Latin America. I don't see a real debate on that. Unfortunately, those agreements that were signed from 2015 onwards are not in force with Chile, but some elements that were embedded in the bilateral free trade agreement with Brazil, trade and climate change, relationships, resources, access to justice, information and participation in environmental matters, very, very important issues. that to some extent may serve to buttress the whole conception of the insertion of a country like Chile, which is highly dependent on foreign exchanges and foreign investments, and that have to be regulated for the good. Thank you. This is my first intervention.
But not the last. Thank you, Maria Teresa.
You.
Jorge, we've mentioned environmental issues, and I wonder if you could give a perspective. And I would note that one of the questions that comes through highlights the NGO objections that have been lodged to the EU-Mercosur agreement that Pedro mentioned. So love to hear your thoughts on this.
Happy to offer some, but just very, very briefly, I guess that the main thing to keep in mind, and this is not just applicable to the agreements that have been concluded with Latin American countries, but essentially to most of the agreements, FTAs, and investment agreements as well, is that these agreements are essentially built to enable and protect investment and trade flows. So the protection of the environment in these agreements is a regulation of a negative externality. And that regulation of negative externality, it takes really two main forms, and we have stayed there. There is a lot of innovation, but very little at the same time. One is the instrumental approach, which is leveling the playing field. And that has been very important actually in practice. And the second is this more affirmative protection approach, which is to have duties there that actually try to give a bit more overprotect the environment because it is underprotected. Now, why do I say that it is the first rather than the second has seen more developments? Well, simply because many green industries have used the trade and investment disciplines, the traditional ones, to find some measure of protection. And this is how they are actually changing the impact on the environment, which is quite curious. If you see it from that perspective, it's not by changing the language, but by using the old language, but that use is being made by a different sector.
Very interesting. And this really glides us into the second topic that you are taking the lead on, so we can just continue to develop this. But we are in a period of reform of investment agreements in a process that's been primarily global, more than regional, although there are some regional developments that have been referenced. So, but let's focus on those in terms of investment. The new NAFTA gutted Chapter 11 going forward. As has been mentioned, Brazil has a relatively new model of a bilateral investment treaty. And we're seeing a host of new issues being raised in these disputes by way of either defense or counterclaim by states, whether it's corruption, human rights, or environmental issues. And so, Jorge, please give us your views on what's happening, in particular in the environmental area, and what you see the implications as being.
Yeah, sure. I mean, the trend is very clear. Huh? The trend is very clear, both in terms of the treaty language and in terms of disputes with environmental components. In terms of treaty language, although if you take the entire set of treaties, old and new, and I'm talking about investment agreements and investment chapters of FTAs, if you take them all, there is only a minority that refers to the environment. But if you look at them from a chronological perspective, most of those that have been concluded started in the 2000s roughly, although the NAFTA already, I mean the real one, had something very ambitious in it. But most of the new ones have environmental language in them. But again, this environmental language, which really looks at the two approaches that I just mentioned, the instrumental approach, which is leveling the playing field, or the more affirmative protection approach. When you look at the practice of both trade and investment panels, what you see is that what really matters is the change in the underlying sectors, in who is using them rather than how they are being used. Now, if we look at trends in that respect, of course, we would see that the first trend would be the increase in the amount and the number of disputes. So on my count, you have something like, let me see, I have it here, 178 public disputes, public investment disputes with environmental components out of 1,061, so roughly 15%. Most of them have been brought after 2008. So my count is between 1972 and 2020, but most of them have been brought after 2008. And most of those disputes, they relate to renewable energy, modern renewable energy. So this is very clearly, they are being brought by the new sectors. It's green against a state. It's not brown against a state because the state wants to go green. So you see that it's not the protective, the affirmative protection, but it is much more the other side, the instrumental protection. Now, the Latin American practice is fairly interesting for one reason. Latin America is usually the experimentation ground. Now, to say that Latin America has been at the forefront of the experimentation is not pleasant, actually, because it has really suffered from that in many cases. But there are a number of issues where Latin America has been testing the ground, or Latin American disputes have tested the ground. I will just mention three that I find really interesting. The first is the one that you mentioned earlier, Lucinda, is the counterclaims with environmental grounds. There are four main cases, and there are many. There are a few cases with counterclaims, very few where counterclaims have been successful, and they are in Latin America. And those four cases, three of them are environmental counterclaims. One of them is much more of a human rights, economic, social, and cultural rights, essentially the right to water. The peculiarities, I would say, in those cases is that in two of them, the environmental law that is applied is domestic environmental law. Those are the two cases against Ecuador. And then in the two others, there is some reference to international law. Those are one against Costa Rica and another one against Argentina. So you have some sort of blade trails tracing phenomenon, path breaking, I would say, but I'm not saying it, I'm saying it with a heavy heart sometimes because this experimentation ground is uncomfortable. Second and third areas where Latin America has been, or Latin American disputes have been interesting. One, which is absolutely key, but it is a very shy development. There are many new environmental clauses in investment agreements, but we still don't know how they're going to be used because there are very, very, very few cases in which they have been used. One is an old case, is S.D. Myers against Canada. Then you have another case, which is not in Latin America, Al-Tamimi against Oman. And then you have an interesting case in Latin America, a CAFTA case, which is Spence International against Costa Rica, in which two non-disputing parties, they had the United States and El Salvador, they had a different interpretation of how these clauses apply. And one of them, I think, has a lot of future, which is not just this environmental clause as a tool for interpretation. That's obvious. You don't need that. Even if there is no clause, you can look at customary law, but as a presumption of conformity, as a sort of safe harbor. And that would be quite interesting. The question is still wide open, but I think it's again, something very interesting to keep in mind. And the third point, and very, very much my last point, is the fact that Latin American cases, and one specifically, Allard against Barbados, are opening one road that is obvious to anyone dealing with human rights, the so-called human rights approaches to environmental protection. So claiming under human rights, under a human rights court, and saying that a human right requires some environmental protection. Well, that has been done in one case, to my knowledge, in Allard against Barbados, in which the investor is not using human rights approaches to environmental protection, but investment approaches to environmental protection. And not in the usual way, just renewable energy disputes, but in the very specific way of saying, because this state has not respected the Convention on Biological Diversity and some other international environmental agreements, this state has breached its investment agreement, its investment obligations. It's obvious in human rights, obvious. There has been going on, and that development has been on since the 1990s. But in investment is only starting, not sure why exactly, but I guess it's just a matter for council to ponder. Thank you very much.
Jorge, thank you for that very interesting intervention, and I'm sure our participants have found it fascinating as well. Pedro, what's your perspective on this issue of kind of new issues, defenses and counterclaims, not just in the environmental area, but they're fair game as well? Pedro, you're muted. Pedro, you are muted. We can't hear you.
No. Thank you. I'm sorry, the mute just wasn't working. I apologize for it. I think it's an extremely important one. Jorge was talking about the case against Argentina having to do with water rights. And that case is particularly interesting, I believe. It's Untitled versus Argentina. That sets forth, there was a counterclaim basically alleging that the provider of services did not do its job and sanitation, and there was a right to water, sanitation water, potable water, and that the non-performance was more than just a non-performance of a contract. We see also in the energy sector, just recently a case came out where the respondent state, in that case, Colombia, had alleged a counterclaim for $500 million. It was denied, but it's an area that I think, regrettably, the lab that Latin America has served to the Petri dish for giving rise to these claims will help. It will help. It will be a very affirmative contribution to public international law, because the new treaties you see now, for example, right to water as a memorialized right contained in trade agreements and bilateral and bids. So this is, I think, extremely important. The historical problem has been one that has been foundational in nature, namely consent. Is there consent? Typically, those fall around Article 10 of the treaty. I know I'm generalizing, but it's plus or minus one. And the question is whether all claims arising from this investment, does that mean counterclaims? Does that mean protection standards or principles of law that were not part of the negotiation, are not part of the plain language? Is that just limited to investors who are very clearly defined? Well, now we're in a position to learn from this body of practice and to negotiate these issues. And now I also believe that there's greater horizontal leverage, if you will, if that's not a contradiction in terms, for capital exporting, capital importing states and middle ground states to negotiate and review these very essential terms.
Great, thank you. Alberto, the Brazilian agreement's been mentioned. You'll need to take your mic off mute. You're muted, Alberto. Can you say something about what we can expect from this instrument?
Okay, in 2015, Brazil has deliberately decided to fly from the traditional model of bilateral investment treaties. Brazil decided to fly this model for two reasons. First, due to the mistrust involving the clauses of bilateral investment agreements. And the second reason is the Brazilian suspicion that those agreements impaired were prejudicial to developing countries. This is the context. Brazil called its model Agreement on Cooperation Facilitation of Investments. The main question is to favor investment and cooperation rather than disputes. There are three main features of the Brazilian agreement. The first feature is represented by thematic agendas. And these three features are expression of the Brazilian experience as the recipient of foreign investment, and Brazil as having companies, corporations investing abroad. The first feature, as I told, is composed of some items, for example, visa proceedings, programs on money transfer, and environmental and technical certification and licenses. The second feature is the improved governance, and the improved governance is a fundamental aspect with two important components. The first component is the creation of a joint committee. A joint committee is composed of states officials of two countries, of the investor country and of the recipient country, and the ombudsman. And the ombudsman was inspired in the figure created by South Korea in 2010. And ombudsman aims to approximate the state with the foreign investment and to peacefully settle a possible dispute. And
Alberto, if I can just jump in here, I think well, let's hold the third point just in the interest of time. Maria Teresa, I hope we can get your comments on this topic, and then we need to move into the next topic because our hour is going very quickly. Thank you. You're on mute, Maria Teresa.
Sorry. Yes, now it is okay. Well, I think that there are some points that address the question, the role of companies, how to attract the interest of companies in the environment, public health, safety regulations, and how can companies contribute to the goal of sustainable development. And I think that is the other side, one of the other phases of this, the question we're addressing in this panel. It's not only the question of measuring the substantive contribution or non-contribution of companies, but also looking at certain standards of conduct that we can require from them, and at the same time, standards with which they have to comply. For example, how to interrelate the question of the non-discrimination on the side of the state or the government with the regulation of business and the struggle against corruption. I think that is very important. I think we need to have an interplay with companies sharing the same goals and at the same time abiding by certain rules, international and national domestic ones. Second, the ability to support domestic environmental law, labor law, human rights laws, and also the gender perspective, which is a new dimension that to some extent renders more attractive but more complex the perspective of an economic activity. What is being called in the OECD discussion a gender responsive policy to sustain development. This is something which is absolutely a proactive approach. It is not an approach that looks at the situation that doesn't move or that does not can make progress. And to finish with an idea, even if Jorge addressed or mentioned the question of the effect of the side agreements that were part of the some not old but the first free trade agreement, for example, that Chile signed, Canada, the US, and with some other countries, a few countries, on environmental and labor matters. I think even if they were modest, well, the mechanisms may have been seen as modest ones, I think the influence those agreements have had in shaping a community of non-state actors participating in the debate, looking at the phenomena, looking at the situations, and trying to influence and to collaborate with policy-oriented matters. I think that this is very important. Although sometimes clauses embedded in those agreements are seen or characterized as hortatory, that characteristic does not deprive the clauses of the relevance in terms of interpretation and effective application of international standards. And I think that may revert in an approach that is very complementary to the approach of integrating human rights and investments. Thank you, Lucinda.
Thank you. Very thoughtful, and again, it's going to take us right into the next topic, which you will lead, Maria Teresa. And we've talked about corruption. We've mentioned the concept of public order, and it is an important concept in both the domestic and international legal arenas. You've suggested in preparing for this panel that there are some major changes in rethinking in this area, perhaps internationally and domestically. Can you just elaborate on this a little bit?
Very good. If I may be perceived as a bit domestic, but I must say that this is an international debate, ongoing debate in the area of public law more than international law. And I think that we were facing a recurrent discussion regarding the limits of the ability and power of the state to deal with its own decisions on policy matters, which may be curtailed or may be limited by treaties, applicable treaties, and even by international law in general, customary international law. Why is it so? Well, there are some, what I will say, legitimate value-oriented approaches towards the subject, even ideological components in this discussion. But this is a debate as to the nature and power of the state to democratically regulate its own economic and social setting. Well, the question is that this discussion is more acute whenever a state is already party to a trade and investment agreement that may regulate areas such as economic foreign relations agreements, substantive elements of access to natural resources, and other matters. And how to apply those treaties in a changing domestic pattern in which everything is seen from the perspective of a test applied to the government or the state to adopt its own regulations from its own perspectives, like having two different sets of norms without interactions or mutual interactions. This is something which is very apparent in some Latin American countries that already took place, but in a way that led to the denunciation of investment protection treaties only. But I think the debate was more or less the same. But in this case, what I'm trying to highlight is there is a public interest. There is a debate about the public interest, about how to protect if investments need certain amount of protection, which is the role of customary law there. Is it customary law to which we have contributed in the past? What are the responsibilities we have accepted because of the acceptance of foreign investments coming to the country in terms of the ability to regulate or the power to regulate those activities in the future? And I think the question will not be solved ideologically or doctrinally. What we have to see is whether states have been able to manage some conflicting situations in a way not only to prevent the use of dispute settlement procedures, but also to interrelate in a better way, in a more manageable way, the question of the participation for investments and the participation in free trade agreements in a not only a more friendly way with the states' own decisions, but also with policies that are oriented by changing governments and processes. And I think to what extent international law needs domestic law in order not only to be implemented, but also to enhance the possibility of a real perspective of an effective international law. I mean, international law not seen only as a state-to-state normative order, but also a state within the state normative order that is effective and enforceable. I think that is a perspective in which free trade agreements and investment agreements should work hand in hand with domestic law. And domestic law should be able, not a question of flexibility, should be able to provide means to make or to take people or to bring people to better understand what is the impact of an international standard that is applied generally when it comes to domestic affairs. For example, the question of due diligence, the question of paying attention to labor laws, because there is a regulation in international law that requires that an investor looks at the situation of labor laws in the country. I think that is an important perspective, which is more an interactive one. The criticism that international law does not have the necessary legality because it lacks direct enforceability, which is the legal doctrine that is followed by many publicists in Latin America, should be compared with other assertions. It has to be contrasted with the conception that international legal norms and systems are meant to generate common benefits to participants. And it is through the domestic order that this participation in the international legal order has an effective response, may have an effective response. So the regulation of investments is not only a right, but also responsibility for the state in order to render more coherent the participation of the state in the international multilateral setting. That is one question. So, and the other question—
I'm going to have to jump in here, and I apologize. We could go on this for such a long time. It's really interesting.
Excellent.
I see we have 6 minutes left before it's 4
sorry.
o'clock.
Sorry.
And we can run, I think, a couple minutes over, but I want to make sure Alberto has a chance to address the last topic, which takes us into the environmental area more generally, and the issue of climate change, which with our new administration in the US is a priority issue that's being mainstreamed into every aspect of the work of our federal government. And focusing on Brazil, however, there's been a lot of attention to the rate of deforestation in the Amazon under the Bolsonaro administration, so what should be on the agenda for this issue going forward? What should be the priorities from your perspective? And you're on mute, Alberto, so please, please there we go. Please unmute for our last topic.
Thank you very much. I will share my screen, and I use some slides to exemplify what I will tell. It's impossible to share my screen. Okay. The first point, the Brazilian environmental policy dates back to 1970, and with different nuances, this policy continued throughout the different governments after redemocratization until 2018. And this policy combined the defense of national sovereignty, the defense of science, and the environmental protection. It's true that this policy had some flaws, but in general, it projected the country at international level and gave Brazil a soft power at international scene. The second point, there was a tremendous overturn in 2018 with the Bolsonaro's election. With the Bolsonaro's election, the environmental policy shifted fully, and shifted fully thanks to some reasons. Bolsonaro believes that Amazonia should be integrated by colonizing, by populating the area, by allowing agriculturalists to go to that region of the country. And the second, the systematic denial of global warming. And I will exemplify this with some numbers, and I will try to explain how international law and how Biden's administration can face this question. Amazonia. Amazonia presented some focuses of fire in 2019 and 2015. And it's possible to perceive the number of focuses of fire in 2019, 68,000, and in 2020, 103,000 focuses of fire. In the Pantanal region is very important. It is the largest continental humid area in the world. And the numbers are astonishing. In 2018, we had 1,000 focuses of fire. In 2020, we had around 22,000 focuses of fire. And those regions exemplify very well the crisis of the situation in Brazil. And why Brazil is so important. Brazil is important in this area because it is the country that has the most diversified biological diversity around the world, the most largest biological diversity around the world. And deforestation. Deforestation is another question involving Brazil now. We had in 2019, 10,000 square kilometers of deforestation. In 2020, 11,000 square kilometers in deforestation. Prior to Bolsonaro's government, Brazil aimed to reduce deforestation in the Amazon region in 12 million hectares by 2030. But this number will hardly be achieved. Well, how to react before this question? How can international law offer a good response to this question? There is two possibilities. The first possibility offered by Article 20, letter B of GATT 1994. Letter B of 1994 provides that it's possible to set some restrictive trade measures when those measures are necessary to protect human, animal, plant life, or health. This is the first possibility. The second possibility is that foreseen in Article 20G. Article 20G is related to conservation of exhaustible natural resources if such measures are made effective in conjunction with restrictions on domestic production. But the major problem for triggering those measures, the WTO is now in crisis. The reinvigoration of WTO is a topic that Joe Biden will try to negotiate with his partners and mainly with European partners.
Well, Alberto, thank you. I'm going to jump in here because I know we're past the hour and need to conclude. And I know some of our panelists have other events they need to get to. So I think you put on the table a really existential issue, and thank you for your intervention on this. Jorge, I know you have the tightest schedule here. Can I just give you an opportunity? And this is not necessarily on this topic, but anything that the discussion has moved you to comment on in your last words.
Very, very quickly. I'm so sorry I had to leave. I have another one that it was started 2 minutes ago, but I want just to add to what Alberto was saying. I think it's very interesting to frame these things from the perspective of trade, because in the end, what's happening is that in reality, it's the demand from China of certain raw materials that is driving indirectly a large part of the deforestation. This is called indirect land use change. And that could be addressed through a number of instruments, particularly, of course, trade instruments. In Brazil, we will not see it as such, but it would be entirely possible if there was any political will, perhaps not by this administration, but by a later administration, to impose export measures, which are lawful depending on how they are engineered. And those export measures would be progressive on the basis of the amount of exports to China. So, but I will stay there because this is something that we looked at in a project, and I don't want to take more of the space. Thank you very much, and my great apologies that I have to leave now. Thank you very much.
Thank you. No, thanks for your participation and interventions, Jorge. Very, very thoughtful. Pedro, comments from your end?
Just very generally and very briefly on something Maria Teresa said, the relationship between domestic law and international law. It's foundational, and it's one centerpiece of a relationship, and one that we've been wrestling with in our space of international public law, of international investment protection in particular. And we see it highlighted, I believe, when we look at the prudential measures public order exception. That is a very broad public order or public purpose, if you will, exception. But we also see that it has non-contravening provisions in most of the, for example, post-Nafta FTAs, Canada and the United States. For example, Article 12 in the Colombia-US bid. So one last thing to keep in mind is that when we see this vast regulatory sphere in domestic law, we always have to keep in mind that it is inversely proportional to the protection accorded to foreign investment.
Great. Maria Teresa, any further thoughts this discussion has provoked for you?
A final point. I think it is of and to quote some provisions that I have seen in international agreements and also model laws. Taken from Canada and Chile, it is that The parties of an investment or trade agreement reaffirm the right of each party to regulate within its territory to achieve legitimate policy objectives. I think that is a good assertion to start with, such as the protection of health, safety, the environment, or public morals, social or consumer protection, or the promotion and protection of cultural diversity. This is a new subject in trade agreements. That wording is important to look at. And second, taken from some model laws on investments, that contracting parties reaffirm the importance of investors conducting a due diligence process to identify, prevent, mitigate, and account for environmental and social risks and impacts of its investment, which is a good manifestation of a public policy integrated approach. So the state has the right to control that this due diligence is conducted, but at the same time, there is a responsibility on the side of investor to conduct this due diligence so as to narrow the scope of possible disputes. I think those are 2 points that I wanted to highlight at the end of this magnificent panel.
Thank you very much. Well, this is, they say a good settlement is one that leaves both sides unhappy, and a good panel is one that leaves you, wanting to discuss more. There are so many topics we could have gone into in more depth, and we've already exceeded our time by a few minutes. We have some very interesting questions about ISDS reform and whether if the parties can no longer select arbitrators, but they're selected by states, will that lead to biases in favor of states? We have a very interesting question about whether the Brazil model bit turns back, and other bits turn back the clock to the espousal days. We have a very interesting question about the option for states to pursue commercial arbitration models and what that may do to some of these new issues. Perhaps we'll have to have a follow-up program just to talk about all these things. But thank you. First, thanks to my panelists for your thoughtful and fascinating remarks. Thanks to our participants, particularly those who stuck with us into the 4 o'clock hour. We appreciate it. And thanks to both the American Society and the Latin American Society for coming together for this discussion.